Hello, I'm Jessica Ryan Keeney. I am an attorney licensed to practice law in the state of California. I practice family law. I'm also the Department of Child Support Services attorney for two tiny Northern California counties. So today I'm actually not going to talk about a child support issue. I'm going to give a brief overview of the life of a custody case. So this is what's called a parentage case, and it's when the parents of the child or children weren't married, and the cases follow the same course whether it's one child or five children, and they follow the same course whether it's a mom and a dad or it's two moms or it's two dads. There are usually some other details if it's two moms or two dads. I'm going to talk about the children, and I'm going to talk about mom and dad, and I mean no disrespect to any other family structures. So I want to make it very clear that this video is not legal advice. This is for educational purposes only, and any opinions that I express are not the opinions of my clients. They're my opinions only. If you have any questions, you can leave them in the comments below. I will do my best to answer the questions. Those answers will also not be legal advice. Those will just be me explaining how I've seen those matters handled in the past, how I've handled them. It's up to you to go hire an attorney, not me, to figure out if what I'm talking about fits to your case specifically. Okay, so linked in the description, there's going to be hopefully a list of documents. It's kind of long, but there's also going to be a link to my website where you can go find a write-up about this process. This is just a really brief overview. Okay, so the process starts where one of the parents, mom or dad, decides that they need to open a custody case. Now, sometimes this is because the parents already have an agreement and they need a court order, or they want a court order. And a lot of times people wonder, why do I need a court order if we have an agreement? Well, you don't necessarily need a court order, but here's the thing. If you don't have a court order, you might have trouble enforcing your custody agreement. And I'm of the opinion that if you go through the hard work of coming up with a custody agreement, you should have an enforceable order. So you're going to hear me talk about custody agreement, stipulation, and order. And you might just hear me say stipulation as well. Anyway, all three times I mean a court order, a stipulation, and order. So I want to be clear that it's possible to just do a stipulation in a family law case. Oh yeah, let me make it really clear that what I'm talking about applies only to the state of California, but it applies everywhere in California. So anyway, I digress. In a family law case, you can do just a stipulation, and that's an agreement between mom and dad. But unless it's a stipulation and order, then it's not also a court order. And so you don't have the enforcement powers of a court order. So it's possible to just do a stipulation. If you hear me say stipulation in this video, I mean stipulation and order. Okay, so away we go. One of the parents, let's say it's mom, decides that she's going to go open a parentage case. And so she's going to file some documents with the court, summons, petition, UCC, JEA. I'm not necessarily going to go through all of the documents in this video. You can find them elsewhere. Anyway, she's going to file them with court. Usually the case gets filed in the county that the children live in. She's either going to qualify for a fee waiver or she's going to pay the filing fee, which as of the date of this video is $435. That gets paid to the court directly. It's called a first appearance fee. I explain it like a gym initiation fee, but you don't get the benefit of going to the gym. Anyway, so those documents are going to get filed. Mom's going to have those documents personally served on dad. Again, it works just fine if it's the opposite and it's dad that opened the case and mom who gets served, but in this situation, it's mom that filed the case. So mom is going to have someone over the age of 18, not a party to the case, personally serve dad with those documents. And those are the documents that were filed with the court. Now, dad's also going to get served with some blank responsive documents, and dad has the ability to respond or not respond in the case. And so basically that means that dad has the ability to fill out court documents and tell the court what he wants. So dad, if he fills out those documents, is going to get them filled out. He's going to have them served on mom. He can have them served on mom by mail because the court already has jurisdiction over mom. They got jurisdiction over mom when mom opened the case. Dad had to be personally served because the court didn't have jurisdiction over dad. Now, there are situations where dad could have been served by mail and could have signed a notice and acknowledgement of receipt. That's a different video. I'm not discussing that. So dad decides he's going to respond. He has someone over the age of 18, not a party to the case, serve mom with his response documents and draft a proof of service. Oh yeah, mom had to have a proof of service of summons drafted after she had dad served, and she had to file that with the court. Now dad is going to file with the court the proof of service by mail if mom got served by mail, or a proof of personal service if mom got personally served, his response, the UCCJEA. And he's going to have to pay a first appearance fee or have filled out a fee waiver. So now the next step is either the parents reach an agreement or they get a court order about custody and visitation. Now, a lot of times I see the parent who opens the case. I'm sorry, I just had a weird notice on my computer. Hopefully this is working out okay. Anyway, a lot of times I see the parent who opened the case also file a request for order to get a court date to get a custody and visitation order. But let's just say in this situation, mom decides to file that request for order after dad responds. The process is the same. Mom's going to fill out the request for order. She's going to fill out any of the attachments. She's going to take that to court, have it filed. She's going to have to pay a filing fee, and then she's going to have that document served on dad. Now, if dad has already responded, mom can have that document served by mail. If dad hasn't responded, and let's say mom did that document with her summons and petition, then mom will have dad personally served. Okay, so there are service deadlines according to when the court date is for when dad has to be served. I'm not going to get into those here, but just know there are service deadlines. So what's going to happen is if the parents don't have an agreement when that request for order is filed, they're going to end up going to mediation. Mediation is kind of an old term. It's now called Child Custody Recommending Counseling, or CCRC. If you hear me say mediation, CCRC, or Child Custody Recommending Counseling, I mean the same thing. And if you hear me say mediator or Child Custody Recommending Counselor or CCRC, I mean the same thing. So some courts have local forms that you need to fill out so that you can get into mediation. Some don't. Again, topic for another video. Go read your court's local rules, which can be found on your court's website. Anyway, that request for order gets filed, court date gets set, dad gets served. Dad has to also be served with a blank responsive declaration to request for order, and dad can fill out his response. He needs to get that served on mom. Again, can have it served by mail. There are service deadlines, topic for another video. And dad needs to file with the court his responsive declaration and his proof of service. Mom also needs to file with the court her proof of service for having dad served with that request for order so that the court knows dad was served. So now mom and dad are going to go to mediation. In some counties, the kids are going to be interviewed. In other counties, they're not going to be interviewed. And the mediator is going to see if they can help mom and dad reach an agreement regarding custody and visitation. Now, at this point, a lot of people want to talk about child support. I have sometimes seen child support agreements come out of mediation, but you're not there to talk about anything other than custody and visitation. So just keep that in mind. And the focus is the best interest of the children. Now, if mom and dad reach an agreement in mediation or CCRC, the mediator is going to let the court know that an agreement was reached. A lot of times the mediator will draft an agreement and have the parties sign the agreement. Some counties, the hearing or the court date will come off calendar. Other counties, it will remain on calendar. Read your local rules. Ask the mediator what the custom is in your county. Now, if mom and dad don't reach an agreement, then a couple things can happen. If this is what's called a recommending county, then that mediator or the CCRC will make a recommendation for custody and visitation to the court. If this is a non-recommending county, then the mediator will just let the court know that the parties didn't reach an agreement. So it's not uncommon for me to see parties reach an agreement in court or in mediation or CCRC, and then when they get to court, somebody decides to renege on the agreement. And that's a bummer, but it happens. And a lot of times, if the parties reach an agreement and it's a recommending county, the mediator won't make a recommendation to the court. So that can be a little bit tough. Sometimes they still will. Anyway, a lot of times the court will either ask the mediator to make a recommendation or send the parties back to court, back to mediation. Anyway, so let's say you either reach an agreement or you go to court and the court makes an order for custody and visitation. You need to make sure to take really good notes at court so that you know exactly what was ordered, because you might think you're going to remember, but it's really easy to forget the nuances. So write good notes. Some courts are going to give you minutes or a minute order before you leave the courthouse. That's cool. Some courts aren't going to. I always like to get together with opposing counsel or opposing party. So that would be the other attorney if there is one, the other party, the party that's not my client. And I like to look at the minutes if we got a set of minutes, and I like to look at our notes, and I like to make sure, one, we can read the minutes, and two, that we all agree as to what was ordered and that the minutes match what was ordered. This isn't, do you agree with the order? This is, do we all have the same understanding of what was ordered? Anyway, if the minutes don't reflect what was ordered or the parties don't agree about what was ordered, then because we met before leaving court, we can usually go right back into the courtroom, politely get the bailiff's attention. Sorry, my alarm's going off. Politely get the bailiff's attention, have the case recalled, explain the difficulty to the judge, and then the judge can clear everything up. Okay, and so then after court, your order is going to have to be reduced to writing. And I realize if you have minutes, it's already in writing. No, I mean, it's going to have to be reduced to the proper format of findings and order after hearing. So I like to make it clear in court as part of the order who's going to prepare that findings and order after hearing. Sometimes it's the party who won, and it can be difficult to figure out who won in a custody and visitation case because a lot of times neither party gets exactly what they wanted. Sometimes it's the party who drafted the motion, and sometimes if one parent has an attorney and the other doesn't, it will be the attorney who drafts the findings and order after hearing. Anyway, you want to get that findings and order after hearing drafted right away, and then it has to be sent to the other side so that they can review it to make sure it matches what the court ordered. Again, this isn't a question of do you agree with what was ordered. This is a question of does this document actually reflect the court's order? If the parties can't agree that it reflects the court's order, then they'll meet, whether it's verbally, email, written letter, whatever, and they'll try to work out their disagreements about what's in that findings and order after hearing. Sometimes that can't be done. The court needs to sort it out. Read your local rules about the deadlines for the findings and order after hearing, as well as what you're supposed to do if the parties don't reach an agreement. California rules of court also have some rules about what you're supposed to do with that findings and order after hearing. A lot of times the local rules are more stringent than the California rules of court. California rules of court are going to be linked in the description below, and if there's not room, then you can go over to my website and you can look at my outline, which ended up being way longer than I wanted it to, but that's another story. Okay, so now you've, you sent your findings in order after hearing to the court. The court will review it, make sure it reflects what was ordered, send it back. You need to get it served on the other party. And when I say you need to get it served, I always mean someone over the age of 18 and not a party to the case needs to get it served. On the other side, proof of service needs to be filed with the court. Of course, you're going to have to have done a proof of service for having served the unsigned, unfiled findings in order after hearing on the other side. If you don't send it to the court signed by the other party, some point I'll do a video with a little bit more detail on findings in order after hearing. Okay, so right now I'm right about at the 15-minute mark, and I've come to realize that videos over 15 minutes are horrendous and my computer doesn't like them. So this is going to be a multi-part video. In the next part, I'm going to talk about what happens if the parties already have an agreement or if they reach an agreement. So check out the other video. Also, this was a parentage case. Parents weren't married. So make sure that you get an order that states that the children in the case are the children of the parties, because that can be important later on, especially if your order or your agreement includes child support and you later want the Department of Child Support Services to enforce that order. So make sure you get an order saying that mom and dad are indeed the parents of these children. Thank you, and check out the next video.